How's it going, everyone? Geronimo Gutierrez here, again with Poseidon Defense A.P.C, your favorite Orange County criminal defense attorney, LA County criminal defense attorney, based out of Fullerton, California. All right. Oh, did you guys hear about the fire at the circus? It was intense. Sounded good when I thought about it. Well, actually, I got it off Instagram. All right. California arraignment. Your first day in court and what to expect. So you get the notice in the mail, right? Probably freaking out. Your heart starts pounding. You're told you got to appear in court for what the notice says is your arraignment. For most people, it's their very first time in a criminal courtroom, right? And the anxiety, it could be overwhelming. What happens? What do you say? What if I mess up? This single court date can set the entire tone of your case. I'm Geronimo Gutierrez, everyone, Chief Counsel of Poseidon Defense A.P.C. Our firm is dedicated to defending your freedom and guiding you through every step of the criminal justice system in California. Today, we are demystifying the arraignment process, your first day in court, what actually happens, and the critical decisions you will face. In California, the arraignment is your first formal appearance in front of a judge in a criminal case. It's not a trial, but it's important. At the arraignment, several key things will happen. You will be informed of the charges. The judge will read the specific criminal charges filed against you. You will enter a plea. This is where you formally state not guilty. Or I guess you could state guilty, but it's very limited times. Bail will be addressed. The judge will decide if you will be released on bail on your own recognizance, also known as OR, basically a promise to appear at all of your court dates, or if you remain in custody. Attempting to navigate this arraignment process without a criminal defense attorney is like walking into a maze blindfolded. And I have reasons why having us by your side is not just helpful, but often critical. Well, let's start with protecting your rights. We ensure your rights are upheld from the very first moment. Plea strategies, if it's applicable. We advise you on the correct plea. Pleading guilty prematurely can have devastating, irreversible consequences. Almost always, we advise pleading not guilty at arraignment to preserve your defense options. Bail arguments. We will argue passionately for your release on OR or for the lowest possible bail, fighting for your freedom immediately. Immediate case review has to happen. We can begin reviewing the charges and initial evidence. Offering immediate insights. You have to set the tone at this time as well. Our presence signals to the prosecutor and the judge that you are taking this seriously and you have professional representation. Because a lot of the time, sometimes people show up and they'll say, "Can you give me time, judge, to get an attorney?" They come back Can you give me more time, Judge? Can you give me more time? There's a lot of reasons why, but it's good to start off right with an attorney, right? The courtroom can be intimidating, right? Your first time. Here is what you can expect and how to conduct yourself. Dress code. Dress respectfully, clean, modest clothing. This shows respect for the court and can make a positive first impression. The last thing you really want to do is show up with your new Yves Saint Laurent Gucci bag when you're trying to fight welfare fraud. Just be mindful of the charges, and you just want to have a neutral appearance, really. Addressing the judge. You always address the judge as Your Honor. Speak clearly and respectfully. The adrenaline gets going. A lot of people start speaking fast. And it's hard, your mouth, you get your dry mouth. It's tough. Speaking only when necessary. Big point right here. Do not interrupt the judge or the prosecutor. Wait your turn. If you have an attorney, they will do most of the talking. The situation, you got to keep it simple. No cell phones. Turn off your cell phone. Absolutely no recording or photography in court. You got to be patient too. The court can be a slow process. Be prepared to wait. Your case might not be called immediately. Might not even be called in the morning. You might be told to come back after lunch. Understanding your plea options. Not guilty. This is the most common plea at arraignment. It preserves your right to fight the charges, review evidence, negotiate. Your attorney will always advise this most of the time. Like I said, rare occasions we could do a guilty plea, but few and far between. Guilty, no contest pleas. These pleas mean you admit guilt. Once entered, it's very difficult to reverse. Do not plead guilty without first consulting an attorney. Let's see. One of the most immediate concerns at arraignment is whether you'll walk out of court, right? Or if you will be taken back into custody. The judge will make a decision regarding your release, often based on a bail schedule set by the county. Each county has their own bail schedules. Bail. This is a financial amount set by the court that the court that you or a bail bond company pays to ensure you return for future court dates. There's also Own Recognizance release, OR release. If granted, you are released without having to post bail based on your promise to appear. This is what your attorney will fight for, demonstrating your ties to the community. You have a job. Are your family present here? Lack of flight risk. Again, you have kids here. Are you a business owner? You have to stay here. You're not going to try to skip town, skip bail. There's other factors too. The judge considers severity of the crime, your criminal history, danger to the community. Your attorney will present arguments to mitigate these factors. Once arraignment concludes, your case is not over. If you plead not guilty, you get another court date. And now you have to deal with pretrial hearings where legal motions are filed and discovery occurs, which is the exchange of evidence between the prosecutor and me that they are required to give us what they're claiming as evidence against you. We also got to initiate negotiations. We will engage in plea bargaining with the prosecutor to try to achieve the best possible outcome. And of course, it's a plea bargain only if it's applicable, right? Because first of all, has to be acceptable to you. And second, you got to actually accept it. And that's very case dependent, right? So not all of those cases are not always going to end in plea bargains. Sometimes you got to take it to trial. Trial is, when if no resolution is reached, the case may proceed to trial. Your arraignment is not just a formality. It's a critical proceeding that impacts the entire course of your criminal case. If you or a loved one has been given notice to appear for arraignment in California, state or federal charges, contact Poseidon Defense immediately. We are here to prepare you, protect your rights, and begin building a strong defense from day one. Give us a call at 714-978-9988, 714-978-9988, or visit us at PoseidonDefenseLaw.com. But that's it, everyone. And again, if this video helped demystify the arraignment process, please hit that like button. Subscribe to our channel for more vital legal insights and ring that notification bell. And please share your questions below. We're here to help you understand your rights. I want to try to bring some very relevant content for you. So just drop a message, drop a comment. Let us know what's going to work out for you. But again, thank you for the support, everyone. And have an outstanding week. We got some heat coming up. Got a nice neck fan from my wife. It's freaking awesome. You should get one. But yeah, have a good week. Stay safe out there, everyone. Geronimo Gutierrez from Poseidon Defense, your favorite Fullerton criminal defense attorney. Have a good week.